Not how long the case has been pending, not what complaint you're attacking.
And this was pending for 2 years?
This particular case was pending for approximately 2 years.
And
Yes.
this is expeditious?
Well, the plaintiff had several opportunities to file a successful pleading, and there was a couple rounds of demurs where the demurs were sustained. The plaintiff had a chance to revise their complaint. They did, and the anti-SLAPP was filed timely.
2 complaints prior to this one, right?
3 complaints.
3 complaints?
Correct.
There were 3 complaints total?
4 complaints.
4 complaints total. In any of the prior 3 complaints, the 2 amended complaints, could the anti-SLAPP motion been filed?
Yes.
So why isn't that the end of the story?
Because the statute itself doesn't say that it's the end of the story. There's nothing in the statute.
But if the purpose of the statute is to expedite this process, why isn't that the end of the story?
It still is expediting the process, whether it's the Second Amendment complaint, the Third Amendment complaint, the 15th amended complaint. That is a new complaint, and if it's filed within 60 days, the legislature has made it clear that we can be heard on that as a matter of right.
But, Counsel, if I could ask you a variation of Justice Chin's question. So how does it better advance the purpose of the statute to read it the way you were asking us to read it, which allows some expediting relative to a world with no anti-SLAPP statute, but doesn't seem to expedite things relative to a world where we would read the statute to require that there be some new claim addressed in the anti-SLAPP motion, for example, to allow it to be filed beyond the 60 days?
If I understand your question, in this case, it was not filed beyond the 60 days. It was filed within 60 days of the service of the Third Amendment complaint.
Correct. But how does that particular reading of the statute better serve its purpose than the alternative, which is to have us sort of not take the approach that you, the Signet Bank, took, but instead to inquire whether there was no way to file it earlier, and only in those circumstances to allow it to be filed after a series of successive complaints?
I understand. As an attorney that practices in trial courts every single day, when you get served with a complaint, there's an arsenal of different tools that you can use to challenge that complaint, whether it's a demur, an MJOP, a regular motion to strike, or an anti-SLAPP motion. Those are tools that the defendant has. And just because you choose one tool doesn't mean you've waived your rights to use the other tools in the event the complaint is amended at a later stage, which happens regularly. And in this case, the original complaint was on a judicial counsel form, and there was a demur that was filed in response to that, and it was sustained because the plaintiff had failed to show that a valid contract existed. So from a litigant's perspective, sometimes filing a demur is preferable to filing an anti-SLAPP. And if we can knock out a case on a demur at an early stage, that's just as effective as knocking it out on an anti-SLAPP. And I will say in this case, the Third Amendment complaint that was a motion to SLAPP was filed against it. That contained 2 new causes of action, which had never been alleged in the previous complaints. And there's a prefatory instruction in the complaint that says all these allegations should be read as one, and when doing so, it creates a new complaint. We've got these 2 new causes of action that include new factual allegations that weren't in the previous complaints.
What would the strategy be for filing a anti-SLAPP motion to a Third Amendment complaint when you could have knocked the case out at a demur or one of the other tools in the arsenal? Because, as we know, a SLAPP motion has some serious consequences and also some benefits like attorney fees, chilling discovery. When you talk about practicing in the trial courts every day in your arsenal, why wouldn't you file an anti-SLAPP motion in the first instance as soon as possible?
Expense, time.
Versus continuing discovery, versus the fact that you can get your expense back on attorney fees and cost as allowed by the statute. Those arguments aren't very persuasive.
Well, maybe you don't have the evidence that you need on an original complaint, and you choose to file a demur and engage in some discovery while that demur is pending. and then you get evidence later, they amend their complaint, now you have evidence.
After the complaint's been filed, what evidence do you have? You mean you'd go through a discovery process? You'd go through the expense of something like that
Well,
in order to later file something that tolls discovery? You get your fees and costs? I'm just asking this because it seems like maybe, potentially, speculatively, filing an amended complaint, filing a slap to a third amended complaint to the original complaint was in fact a mistake. It was a recognition later on, down through the case, that maybe we should have filed the slap motion, and now it's an effort to get that slap motion heard as to the original complaint.
Which is exactly what happened in the U case, where they could have filed it earlier,
Right.
and they chose not to.
Right, or in this case, could have, should have, maybe should have, but didn't, because of all the benefits of a slap motion. And then you heard all the questions about a purpose. The purpose of having this tool in your arsenal is to expedite and to ensure this frivolous litigation or litigation that chills participation. And we know in the first instance of 425.16 that the legislature was concerned about the abuse of the judicial process. So all of that background leads me to wonder why we would allow a rule that allows a slap motion to be brought to a third or to a later amended complaint and not to the original, or as soon as one could be brought.
Because that's what the statute says. It doesn't have the language.
Contrary to the purpose, isn't it? You've heard that all off from this bench. Your position is contrary to the purpose of why the legislature even enacted the slap motions.
I don't believe so. And in this case, if you look at what happened, there's new allegations in the third amended complaint. So arguably, it's at an early stage. No discovery has been done on these.
Am I wrong in understanding that your slap motion brought a complaint against the original complaint and not to new material in the third amended complaint?
There was no slap filed to the original complaint.
Exactly.
Yeah, it was to the third amended
Exactly.
complaint.
But when it was filed, it was to allegations that had already been in existence in the original complaint.
It was to the entire complaint. Some of the allegations.
Counsel,
Yeah.
just answer my question.
Yes, some of the allegations that were slapped were allegations that had appeared in the original complaint. And then there were new allegations that hadn't appeared in any of the previous pleadings. And those allegations on the face of the complaint were told to be read together as one unit into all the causes of action. They were incorporated by reference into each cause of action. So it changed the complaint. It was a new complaint. And at that stage, the legislature has said you have 60 days to file your motion as a matter of right. And if we would have waited past the 60 days to file the motion, I think that's where the court can look at the Hewlett-Packard case and the direction that that court provided, where they talked about different things that the court can take into consideration in the event it wants to entertain a late filed motion. But here, this motion was not late. There's nothing in the statute that says a litigant waives their right to file an anti-SLAPP if they don't file it to a previous complaint.
So there's almost like a principle that you're announcing, I think, or at least what I hear your argument to be saying in response to the Chief Justice is, if the statute does not clearly address the matter, the litigation strategy choices that counsel can make are presumed to remain on the table. And if counsel, for example, has a reasonable conclusion that he or she makes that it's preferable to file a demur rather than to wait and do an anti-SLAPP later, if that doesn't work, then the statute should be read to preserve that kind of choice.
I believe so. There's nothing in the statute that says you've waived your right. And if you look at the demur statute, it does have language in there that talks about you're prohibited from demurring in an amended complaint to things that you could have demurred to earlier. That's 430.41 Code of Civil Procedure. So when you look at that statute and you compare it to the anti-SLAPP statute, the legislature certainly knew about, hey, if we want to prevent this from happening, we can add language similar to the demur statute, and they chose not to. And I believe the reason they chose not to is because if you're at a stage where there's an amended pleading and the court's going to balance, okay, do we let the defendant file this anti-SLAPP to amend a complaint even though it's timely within 60 days, or if they waive their right and now we're going to balance it and allow a arguably frivolous complaint that the statute says are designed to abuse the judicial process, we're going to let that move forward because the defendant has waived their right. I think when you look at what the Baral case says about the purpose of the statute, it's completely contrary. The statute is designed to shield the defendant's constitutionally protected conduct from the undue burden of frivolous litigation. If the litigation's frivolous at the original complaint or the third amended complaint, it's still frivolous. And if we file it within 60 days, these other cases have said it's a matter of right. And I think the 4th District got it wrong here in creating this new standard that now, the last part of our argument was that this creates a problem for the trial courts and litigants, because now a trial judge sitting in Superior Court, if they're served or if their anti-SLAPP motion is filed to a third amended complaint within 60 days, the trial judge can no longer look at the proof of service and the date of filing the amended complaint to determine timeliness. They can't do that. Now they have to actually open up the complaint. They've got to look at the allegations. They've got to look at the previous pleadings, allegations, compare those two, figure out what's new, what's not new, and that's just to determine timeliness. They're not even to the actual two prongs of the anti-SLAPP analysis. So by adopting what the 4th District has done in this case, it creates a problem at the trial court level.
Could you describe the problem to me again? You're saying it creates a problem. You're suggesting that it's some onerous burden to look at different versions of the complaint and decide whether or not the allegations in the third amended complaint presented themselves in the first or second amended complaint or the original complaint. What is the burden of doing that? Why is that such an onerous burden?
Well, the flip side is it filed within 60 days, yes or no? And if it's a yes, that analysis is done. And then you go on to the two prongs of the anti-SLAPP analysis. But what the Hewlett-Packard Court is suggesting that this 4th District adopted is that that isn't the analysis. You actually have to open the pleadings, look at the protected allegations, figure out when they were first alleged, and then if you look at the Hewlett-Packard Oracle case, they want to know why you didn't bring it earlier. But in that case, it wasn't filed within the 60 days. It was filed literally almost 2.5 years later, and the court denied discretion to hear it. So what I'm trying to articulate is that a trial judge faced with an anti-SLAPP motion shouldn't have to do an analysis of opening up all the different complaints, looking at the different versions, figuring out what's new, what's not new.
That's what I'm still wondering is why is that such a terrible burden for the trial court to simply read the complaint and determine whether those allegations that purportedly chill the exercise of free speech rights presented themselves in an earlier version of the complaint. Somehow it strikes me as a very simple process. It doesn't inject any particular complexity into a trial court's obligations. But I think I understand what you're saying.
Okay, thank you, Your Honors. We'll reserve the remaining time for rebuttal.
Thank you, Mr. Blake.
Good morning, Your Honors. When the trial judge first was presented with this issue and we were briefing it in the Superior Court, I was under the impression that the entire complaint or the entire anti-SLAPP motion as to all of the causes of action was untimely for various reasons that Your Honors have raised, that there's been multiple demurs, there's a motion for judgment on the pleadings, motion for summary judgment as to two of the causes of action, the breach of contract claims that have remained in all of the versions of the complaint, and specifically the second amended complaint, which survived MSJ and motion for judgment on the pleadings. However, I think the 4th District's ruling accurately reflects and upholds the predecessor of case law, the U case and the Lamb case, in the sense that, and even the Burrell case, in the sense that it allows a amended complaint that brings new allegations or new causes of action, such as the allegations of promissory estoppel and quantum merit that were raised in the third amended complaint. It allows an anti-SLAPP motion to attack those allegations. And if successful, then the issues will be narrowed for trial, and the cost and the burden on both parties, both plaintiffs and defendants, will be limited.
Why does it matter if that happens earlier rather than later?
Well, earlier rather than later upholds the purpose of the statutory or the anti-SLAPP motion.
Well, what I mean is what efficiency is achieved, because the same effort has to go into evaluating those claims, and presumably, I suppose, the plaintiffs can make the same set of tactical decisions as to whether to keep certain claims or not, but all those can either be made at time one or time two. What's the efficiency?
Well, the efficiency is that it just happens earlier. I mean, this was originally filed in July of 2013. This July will be 5 years that this case has been going on for. And since June of 2015, we've been in the appellate courts.
Can you fathom a strategic reason why, given the age of this case and the arsenal of consequences that flow from an anti-SLAPP motion, that a successful anti-SLAPP motion, that there are so many years in civil procedure moves of demur and MSJ, JNOP that occurred before there wasn't even an anti-SLAPP motion brought in this matter, the original?
I agree. I don't understand why there wasn't one. If a party is so concerned with their free speech being infringed upon and chilled, you would imagine that since this is a tool and a mechanism that you have within the first 60 days, I would bring it before even bringing a demur.
Well, and it's a remedy, and it speaks to efficiency of the process for the litigants, but also the trial court, does it not? And the Court of Appeal, in terms of all of those motions, well, not necessarily the Court of Appeal, unless it was a demur without leave to amend, but it's also a procedural efficiency for the trial court to knock out a cause of action after the first 60 days, rather than hear demur, amended complaint, demur, leave to amend, demur, summary judgment, well, discovery, summary judgment. I'm trying to understand the purpose of why one wouldn't bring strategically an anti-SLAPP motion as soon as one could.
Right. I can't. I don't know one as well, especially when it puts such a burden on the plaintiff to provide evidence, just like a summary judgment motion to support your claims. If it's similar to a demur, I know counsel brought up the demur statute has specific language in it that once you bring a demur on an issue that you can't bring it again. Well, that doesn't have as serious of a consequence as the anti-SLAPP motion with the attorney's fees and other issues that Your Honor raised. So I don't know. I would bring one if I litigated defense.
Can I ask you a question I meant to ask, and I'll ask on rebuttal of the petitioner, and that is, what's your understanding of the corporate status of either Newport Harbor Ventures and the Vertical Media Group?
Yes, Your Honor. So as of yesterday, I looked online and I submitted a declaration, which was filed yesterday, that showed Vertical Media Group was active in both Delaware, or good standing in Delaware, active in California, and the Newport Harbor Ventures is active in California as well. So my understanding is that all of those parties are able to be here today and me present on their behalf.
Thank you.
I think this case shows a polarization of facts that yield itself to providing some mechanism, some procedural tool to allow plaintiffs to not have to go through the gamesmanships and the delay tactics that the Hewlett-Packard case spoke about with the defendant's tactics of filing it, basically on the day of trial or in between the two phases of trial. So our position is that the Fourth District, their opinion was accurate. It supports the facts of this case. The trial court, had they been presented with this rule of law, would have done the same thing that the appellate court did, which says that the protected speech that was at the heart of every single complaint had been present as to the first two breach of contract claims, and that the two new added causes of action for promissory estoppel and quantum merit should be tested to see if they do survive an anti-SLAPP motion. And they would have gone through the same process that the appellate court did with the evidence that we presented and overruled or denied the anti-SLAPP motion. So unless your honors have any more questions, I would submit on a brief.
Thank you, Mr. Hermans.
Thank you.
Mr. Watts, before you begin, do you affirm that you are in good standing, both VMG and NHV, in California and Delaware for the former and Delaware for the latter?
I have no personal knowledge of the corporate status of either of his clients.
Oh, I'm sorry. Do you have any position on that?
Just that the last time that we requested a certificate from the Secretary of State of Delaware, they said that Vertical Media Group had been defunct and not in operation since, I believe, either March or May of 2015, which means that every brief that they filed in this court, the third amended complaint itself, they were filed by a non-existing corporation. So that's the last information we had. That was around December 22nd or so. We had filed an opposition to their request for judicial notice with the most recent version of the certificate we got from the Delaware government, and that's the last information that I had. Newport Harbor Ventures, I have checked the website. I mean, none of this is in the record, but I have checked the website. The Secretary of State has been convinced that that company has paid its back taxes or whatever, but again, they were not in good standing. Neither was Vertical Media when the briefs were filed, when the third amended complaint was filed, when the anti-SLAPP motions were filed. None of those. Vertical Media Group had been defunct since March or May of 2015.
But they are now, as far as you know.
What was that, Your Honor?
They are now, as far as you know. They're active.
I don't know.
What does the website indicate?
The California Secretary of State's website shows that they have the ability to, that they're active in California. So their status in Delaware, I don't know.
Information contrary to that?
Other than the certificate that I got from the Delaware Secretary of State in mid-December, but I have nothing from the California Secretary of State since, I mean, in the last 2 days, I don't have anything from them.
The last time you checked, they were both active.
On the website said so, yes, that's what the website said.
Thank you.
That's all I have. Thank you. Daniel Watts for the appellants. I'll respond to a couple of points. The first one is that the language of the statute is what's most important here. And the language says that 60 days, that 60-day period reopens after service of the complaint. That's the rule, service of the complaint. It doesn't say 60 days after insertion of allegations into the complaint, or 60 days of the first time that a defendant believes with good faith that they might be able to win an anti-SLAPP motion. It says 60 days of service of the complaint. That's the rule. The rule is black and white. The rule has been applied in the way that we're asking for since the history of the anti-SLAPP motion. Even Hewlett-Packard and the other cases that were cited by the 4th District, in those cases, the court said, in Hewlett-Packard, they said the anti-SLAPP motion was timely. This was an anti-SLAPP motion that had been filed in the, or that one was untimely. That one was untimely. But they said that if there had been an amended complaint, they could still file an anti-SLAPP motion. It arises as a matter of right, even if it's filed years after the original complaint. In Brawl versus, so in Hewlett-Packard versus Oracle, in that case, the defendant had filed the anti-SLAPP motion after trial had begun and over a year since the complaint was last amended. So that was obviously untimely. And that's when all of those policy considerations come into play. If it's an untimely motion, one filed outside that 60-day period, the trial judge has discretion to hear it or not. And that's when the trial judge can decide whether it makes sense to allow an anti-SLAPP motion to be heard because of the late stage of the proceedings, how much money has gone into discovery, even whether it's likely to succeed. And that's written into the statute itself, too. The statute says that other than that first 60-day period, the trial judge can hear the anti-SLAPP motion.
Counsel, even if one accepts your argument that the statute as written doesn't seem just by its text to compel that the court accept the argument on the other side, isn't it just a little ambiguous at least? I mean, is it your position that we look at the statute and with no further analysis, there's no other conclusion that can be supported other than the argument that you're making?
Yes, Your Honor, and that was the decision of every other appellate court until the 4th District.
But tell me why that's the case. Just, I mean, the flip side of the coin, of course, is that nothing in the statute, unless you point me to something I haven't seen in the statute, addresses the question of successive amended complaints.
It says 60 days of service of the complaint. So in order to change the word the complaint, if you want to find ambiguity in the statute, it would be in the term the complaint. What does it mean when it says the complaint? Is an amended complaint the complaint? Yes, it is. A big dog is still a dog. An amended complaint is still a complaint.
But is an amended dog still a dog, counsel?
Yes, until you add too many things to it. But it's still a complaint. An amended complaint is still a complaint. And 60 days after service of the complaint that's being targeted.
Yes, I mean, I acknowledge you can make the case that that's what the statute means. That's the case you're making. I guess you can also argue that there's no other way to read the statute. If you don't persuade that that's the only way to read the statute, what else supports your position? So
if you read the other statutes that govern challenges to the complaint, like the Demurrer statute, it's just the timeliness part, putting aside 430.41, the newly enacted statute that restricts defendants from challenging allegations that appeared in earlier versions, earlier complaints that they could have demurred to before. Put that aside, just look at the timeliness issue, same thing. You can file a demurrer within 30 days of service of the complaint that it targets. Now, no one says you can only file one demurrer in that case. No one says you can only file a demurrer against the original complaint. Maybe you demur based on something you found out, say you found out that the person that filed the lawsuit isn't a real corporation later on, and so you file a request for judicial notice saying that it has been defunct since 2015. Now you have better grounds for a demurrer than you had before. No one would deny that demurrer based on the idea that it's targeting an amended complaint rather than one of the original complaints. Or even, so imagine not any new factual allegations, but take this exact same case. So we have allegations about our clients settling a lawsuit. That's the protected act of petitioning, settling a lawsuit. And in the original complaint, you had breach of contract causes of action. Now they add causes of action for quantum merit and promissory estoppel. Are we not allowed to demur to those? Are we not allowed to challenge those? Because we could have demurred to the entire complaint earlier on. We could have demurred to the factual allegations earlier on and say they don't state a claim for breach of contract. And I mean, in fact, we did demur to those things, but we're not going to say that we're not allowed to demur again. And then moving aside from the timeliness, I mean, look at motion for summary judgment, all the timeliness clauses of these challenges to the pleadings, they talk in terms of services of complaints, not insertions of counts or claims or allegations. There's nothing in the timeliness clause that talks about inserting allegations and that is the triggering event that resets a 60-day clock. So the demurrer statute, 430.41, the legislature said, demurrers are too much. They happen too often. Sometimes they're frivolous. Sometimes they just delay. So we're going to add this limitation on demurrers. You can't demur to a portion of a new pleading that you could have demurred to before. They could have done that in the anti-SLAPP statute, and they didn't. And the fact that they didn't, that silence speaks a lot. The legislature knows how to fix this problem if they think it's a problem. All of these policy considerations, there are two places to make the argument. They're not here. The one is to your state senator to say these are a problem. There's delay. We don't like the discovery stay. We don't like the right of automatic appeal, but those are still in the statute. The right of automatic appeal delays cases, doesn't it? The right of automatic appeal, the discovery stay, all of that is dilatory. All of that can delay the case for years. But we want to get rid of the right of appeal because it's straight there in the statute. We want to get rid of the discovery stay because the discovery stay is in the statute. So we shouldn't get rid of the right to file a new anti-SLAPP motion within 60 days after service of the complaint, because that's also in the statute. The other place to make this kind of argument, these policy arguments, is to the trial judge. If we filed an anti-SLAPP motion outside of the 60-day period, a late filed anti-SLAPP motion, the trial judge has discretion to hear it or not hear it on terms they deem proper. That's the language in there, proper. So they can restrict how that anti-SLAPP motion can target claims in the complaint. They can say you can only target newly amended complaints, or maybe you don't get your attorney's fees, or maybe you have to agree to file your briefing on an expedited schedule and waive your right to appeal. Those are possible terms that the trial judge might deem proper. And those policy considerations about how long in a case it is, whether we're the day before trial, those are things that inform the decision of a judge exercising discretion. But all the cases up until this point have said that if you file the anti-SLAPP motion within that 60-day period, there is no discretion. The right of the defendant to file an anti-SLAPP motion arises as a matter of right. And the legislature has commanded the courts to say that this anti-SLAPP section the anti-SLAPP statute must be construed broadly. And in Baral versus Schnitt, the court reiterated that and said, if there's any doubt about what you're supposed to do, you're supposed to err on the side of hearing on the merits of the anti-SLAPP motion. The motion was designed to help defendants, not plaintiffs. The fact that it also might save plaintiffs money by ending their frivolous litigation early is a side effect, but the central purpose is to help defendants. And if we're filing it, obviously we've made the decision that it helps us. And so it does serve the statutory purpose when you serve it, when we file it against the third amended complaint, because anything short of a trial is a huge benefit to defendants. So in Baral versus Schnitt, I was going to say just over a year ago, there were multiple anti-SLAPP motions filed in that case. This court just decided that case. There was the complaint. There was a anti-SLAPP motion filed against the first complaint. It went up on appeal. While it was on appeal, the plaintiff filed another amended complaint. They weren't supposed to do that, but they did. Second anti-SLAPP motion was filed against that one. They stipulated to withdraw it. They added another complaint, and then that one was another anti-SLAPP motion was filed. The complaints weren't that different. The Moss Adams audit, if you recall, the problem was that they had hired an auditing firm to look at the transactions inside of a company. The allegations of the Moss Adams audit, which were held to be pre-litigation activity, so that's why it arises from the right of petition, those had appeared in every version of the complaint. This court didn't even touch on the timeliness issue.
What is your response to the argument that the rule that you propose is contrary to the basic purpose of the anti-SLAPP motion?
It's not, Your Honor. The purpose of the anti-SLAPP motion is to end meritless litigation that impinges on the right of free speech and petition by saving costs for the defendants.
At the earliest possible time.
It's supposed to do it. It's minimizing the cost of the defendants. If they think it's going to be more expensive to file the anti-SLAPP motion earlier on, maybe they haven't talked to their client. They don't know if the contract that's attached to the complaint is real or not. Maybe they don't know if the plaintiff is a valid corporation or not. Maybe they think that they might want to file an anti-SLAPP motion or an MSJ on that, but they need more time. Maybe they think settlement is a possibility. Settlement's always cheaper than litigation. Maybe our clients were talking to each other and trying to settle it and stipulating to these things are going out. Maybe they need to do a little bit of discovery. The anti-SLAPP motion, the defendant, if they want discovery, they can have the discovery stay lifted.
Agree that this anti-SLAPP motion could have been filed earlier.
It could be filed at any time, yeah. We had that opportunity. Not this exact motion, though, because the complaints have changed since then. We've gotten new evidence since then, and things change as the case goes on. The statute itself contemplates the idea that there will be multiple anti-SLAPP motions filed in the case. It says in subdivision B3 that a ruling on an anti-SLAPP motion is not res judicata for anything later in the case. So the fact that an earlier anti-SLAPP motion was granted or denied or heard or not heard is irrelevant to the rest of the litigation. That's not the case for every other motion. The Demurrer statute, the legislature specifically says you can't raise the same issue twice. But if there's an MSJ ruling on something earlier on, that's res judicata for certain ones of those certain issues later in the case. The anti-SLAPP motion specifically exempts itself from that. And I think it does that, contemplating that there would be multiple anti-SLAPP motions in the case. So I think that the legislative purpose is served by this, because the court allows, or rather the legislature allows a trial court to hear an anti-SLAPP motion at any time after the 60-day period. Now, if the purpose of the anti-SLAPP statute is only to be heard within that initial 60-day period of when those slappable allegations first appear in the complaint, why would the legislature have allowed the trial judge, in its discretion, to frustrate the purpose of the statute? So that can't be the statute. The early period that some of the cases talk about when they just sort of opine about what the purpose of the statute is, that early period has been statutorily defined to be 60 days. The legislature balanced in enacting a statute, they balanced the possibility that a defendant might keep their anti-SLAPP powder dry until they were sure that their motion would be granted, versus the significant danger that a plaintiff would bring or would hide their anti-SLAPP allegations or the slappable allegations of petitioning activity designed to chill the defendant's speech until the latest possible moment, maybe right before trial, where a judge would say, oh, there's no way that I'm going to hear an anti-SLAPP motion. Now trial's tomorrow. But that's a question that the legislature has already addressed by enacting this 60-day period. And So that's basically it. I think that the statutory language is clear. It says service of the complaint. That's a triggering event. That's the thing to focus on. And the triggering event is what makes the 60-day period start running. There's nothing in the statute that says that the triggering event is the insertion of allegations into the complaint or the amendment of the complaint. And I think that the legislature intended the word complaint to mean amended complaints. Lamb versus No, all these other cases that are cited in the brief, universally, all the courts of appeal, except for the 4th District, have been applying it the way that we have and saying that you can attack an amended complaint. Brawl versus Schnitt, for example, also says that it's the same thing. Those are amended complaints. The anti-SLAPP motion was filed against amended complaints, not the first complaint. And those allegations of petitioning activity had been in all the complaints up until the court's ruling in Brawl versus Schnitt. So we'd ask the court to consider the motion on its merits and look at it de novo too, because there's an even more dangerous error in the 4th District's opinion, and that's that they allow allegations or claims that are inconsistent with evidence to survive an anti-SLAPP motion. They treat an anti-SLAPP motion like a demur, where you assume the truth of the allegations in the pleadings, like for quantum merit and promissory estoppel claims, and ignore the evidence. Both parties submitted evidence that there's a contract here. As a matter of law, a contract defeats quantum merit and promissory estoppel claims if they cover the same subject. The 4th District said somebody's allowed to plead inconsistent counts in their pleadings. And that's ethically, morally true. You can do that without the threat of sanctions. But when it comes time to prove those pleadings, prove a probability of success on the merits, which is what the anti-SLAPP statute demands of a plaintiff, you're not entitled to inconsistent facts. If both of you agree that there's a contract, and both parties do here, then promissory estoppel and quantum merit are defeated as a matter of law. So just on that point, the court should address the motion as if it's timely, because it is, and then review it de novo, as the appellate courts do for anti-SLAPP motions, and really look at that one holding in the 4th District, because that's even the more dangerous holding. People will, even if the court only overrules the 4th District on the first issue, courts will cite that second issue. They'll still cite the 4th District's opinion, and they'll say overruled on other grounds in this decision. But that 4th District opinion, really, that section guts the anti-SLAPP motion. It makes it more like a demur instead of an early motion for summary judgment, which is the point of it. And if that's allowed to stand, then the anti-SLAPP motion is just a demur. It's just a demur that you can file against amended complaints, because it doesn't have that special demur language in there, but it would be reduced to a demur, and that definitely was not the statutory design of the anti-SLAPP motion. So I'd ask the court to overturn the 4th District's decision, consider the motion on the merits de novo, and grant the anti-SLAPP motion. Thank you.
Thank you, Mr. Watts. The matter is submitted. Thank you, all counsel. Calling the matter of People versus Mark Buza, we welcome the Honorable Dennis M. Perlis, Presiding Justice, Court of Appeal, 2nd Appellate District, Division 7, as pro tem. And when you're ready, counsel.
Good morning, and may it please the court. The question before the court is whether a statute adopted by the voters requiring the collection of DNA identification information from adult felony arrestees at booking is reasonable under the 4th Amendment and Article 1, Section 13 of the California Constitution. The U.S. Supreme Court has answered the 4th Amendment question in Maryland versus King, holding that this is a reasonable search that can be part of a routine booking process. And the answer to the state constitutional question should be the same, regardless of whether this court follows King or conducts an independent analysis.
So can I ask you, so a central focus of the briefing in this case has concerned some of the differences between the California law enacted by the voters and the law that was at issue in King. And I want to begin by focusing on one of those differences, which concerns the timing, not as I understand it, of the collection of the DNA sample,
Right.
but of its transmission to the laboratory for testing.
Right.
The Maryland law provided for transmission of that sample after there had been a charge filed against the defendant and after there had been a judicial determination of probable cause to believe that person had committed the crime.
That's right, Your Honor. That is a difference between the California and Maryland statutes. And parenthetically, I'd note that of the states that have these arrestee statutes, at least half of them, 15, follow the California approach there. Don't think that that can make any difference to the Fourth Amendment analysis, and I don't think it mattered to King, and that's particularly clear when you look at the King Court's statement of its holding, because it says that, quote, taking and analyzing this information is a reasonable and legitimate booking search.
But it only said that in the context of a statutory scheme that delayed the analyzing portion until after the finding of probable cause.
That's true, Your Honor, but I don't think that that was of any moment to the King Court's constitutional analysis. That's not a consideration that it pointed to when it was talking about its balancing of the interest, when it was describing the government interests or the individual legitimate privacy interests at stake.
Also, one possible reason it might matter is rooted less in the reasoning of Maryland versus King and more in the reasoning of some of the California cases construing Article 1, Section 13, which have raised concerns about creating Fourth Amendment rules or rules under our comparable search and seizure provision under the California Constitution that would create an incentive for law enforcement to attempt to file greater charges to proceed against people who have committed relatively low-level crimes as though they had committed more serious crimes in order to gain access to whatever information a booking search might reveal. And that was certainly a concern that strongly motivated the Court of Appeal in this case. Is that something that we should be concerned about? And if not, why not?
I don't think so, Your Honor. And if I might offer a legal response to that and then a practical response to what I think is a practical concern. As a legal matter, I think we recognize that genetic samples, biological samples are different because they contain sensitive information, but the DNA identification profile is a neutral identifier. It is quite similar to a fingerprint, and as a traditional matter in this state and elsewhere, that information has been collected at booking for a custodial arrest. And I think this court in Loader, when talking about fingerprints and other identifiers, has recognized not just that it's appropriate to collect that information at booking, but that it serves important legitimate interests. The practical response, Your Honor, is that I don't think that that is something that should significantly concern the court here, because if you are positing the hypothetical of, say, a police officer who wants to abuse the system in order to obtain information about a particular person, it seems quite unlikely that they would conduct what might very well be an unlawful arrest, could expose them to discipline and even liability. And that's particularly unlikely here because of the mechanics of this system. So if an officer suspects a particular person of a crime, yes, I suppose there's a scenario where that officer acts in bad faith and erroneously arrests the person for a felony, but then that buccal swab is going to be subject to all of the regimented controls of the DNA Act. It's not going to go to the...
Counsel, could I interrupt you there? I mean, I think there's a lot of gray area here. I mean, we don't have to get all the way to bad faith pretextual arrests to observe a practical problem. I looked at the Attorney General's compilation of crime statistics. Okay, this is a government document, your department's document. And the 2016 data show approximately 200,000 felony arrests this is in 2016. 7,000 of these resulted in what are labeled as law enforcement releases. Another 36,000 resulted in complaints denied. Another 26,000 resulted in dismissals and acquittals. So that is fully 1/3 of the felony arrests that did not result in a conviction and were dismissed at some earlier stage, which the DNA Act provides is then erases the legal basis for having the DNA or having the sample analyzed at all. I'm not suggesting that some 60,000 felony arrests happen in California because of pretextual or bad faith reasons, but there is a lot of discretion in this system. That is why 1/3 of the felony arrests that happen in California every year, this is very consistent from year to year, by the way, result in no conviction. That is a massive overbreadth in terms of the amount of data that's being collected on people, where the statute itself then later admits is not a legal basis for analyzing these people's data.
2 points, Your Honor. The first is that's certainly correct. A substantial majority of felony arrests do lead to convictions. Some of them don't, and some of those crimes could be charged in later years that wouldn't be reflected in those statistics. But I don't dispute that there are some minority of individuals for whom that
1,000 individuals a year having their DNA put through the database, and that's essentially, I don't know how else to say it, but it sounds like a windfall, essentially, to law enforcement.
Your Honor, I wouldn't characterize it that way, and I would point the court to Justice Moss's opinion for a unanimous court in Loader, where it was talking about other identifiers that are collected at booking from arrestees. That case involved an arrestee who was not ultimately convicted. And yet the court recognized that having this information and being able to conduct essentially the similar comparison similar to what we do with DNA identification profiles served legitimate governmental interests, indeed substantial government interests. Now,
And part of what makes your answer interesting to Justice Liu and Justice Kruger is that, of course, this label legitimate government interest is broad. It doesn't extend to every conceivable government concern, but it's quite broad. So that leads me to ask 2 follow-up questions. The first one is about the nature of the distinction in the statute here relative to what was at issue in Maryland v. King. So in Maryland v. King, we were not dealing with all felonies. We were dealing with certain serious violent crimes. Is your argument that the nature of the offense is completely inconsequential?
No, I wouldn't put it that way. I think that our argument, and I think that this is consistent with the approach of the Supreme Court in King, the U.S. Supreme Court in King, is that it has to be an offense for which officers can conduct a custodial arrest based on a probable cause determination.
Misdemeanor's fine.
Well, that's not what our statute does, and there may be policy reasons for not doing that. But yes, as a constitutional matter, because all of the interests considered on both the government interest and the individual privacy interest side of the balance would be the same in a situation where you're dealing with another offense, even a misdemeanor, that authorized custodial arrest.
Thank you. I think that's relevant, and I'll reflect on that. The other question is about the nature of the analysis of DNA. So it's clear that the technology we have available is evolving, and what we can learn from somebody's DNA is not going to stay steady. It hasn't stayed steady. It changes over time. So just talk us through a little bit what the scope of your argument is relative to all that government might be able to learn from DNA that might map onto a whole variety of government interests.
Yes, Your Honor. And if I might just note an important threshold point. We recognize that the biological samples collected from arrestees at booking contain sensitive genetic information in the coding regions of the DNA, and that arrestees have legitimate privacy interests in that information. And we do not look at or analyze that information. Indeed, we understand the statute as not allowing us to conduct that. All we do is create a DNA identification profile by measuring certain loci in the non-coding regions of the DNA.
We understand each other, but I'm trying to assess the scope of your constitutional argument.
Right, Your Honor. So I think that the answer, I think where the question is heading, and correct me if I'm not being responsive, is some of the discussion in the briefing of what if there's some hypothetical future use. And I think that the answer is that could affect the constitutional balancing and would have to be understood based on the particular circumstances, whether it's some future change to the statute or some other use made of this information. That could dramatically affect the balancing if, for example, we're dealing with a future use that involves going into the coding regions of the DNA and making predictions about an individual's genetic tendencies.
The current statute prohibits that,
Exactly, Your Honor.
and it makes it a felony to use it for other than identification.
That's exactly right. And we think that the constitutionality should be reviewed on the basis of the current statute.
Well, and that's my predicate question is, it's unclear to me whether or not Mr. Bouza is bringing a facial challenge, because we're talking about hypotheticals and everyone, or an as-applied challenge. What do you understand this challenge to be, facial or applied, which would affect the rule we write?
Your Honor, I think that the formal answer is that it is an as-applied challenge in the sense that Mr. Bouza is literally arguing that the statute that creates a misdemeanor here couldn't constitutionally be applied to him, but that the framework of analysis that has to be applied here, which is a general balancing for reasonableness, it takes on some of the characteristics of a facial challenge. It does contemplate some consideration of circumstances and privacy controls and whatnot that go beyond the specific record in the case. And the effect of upholding the Court of Appeal here would be essentially to invalidate the statute on its face. And I think that that's a very important reason for not going as far as the Court of Appeal did. Even if the court were to have constitutional concerns here, I think it should be focused on the particular circumstances of this statute as it's currently applied, and not based on hypothetical concerns that really should be adjudicated on a developed record in some future case.
Well, let me say, too, I assume that we will see more of this rule or some iteration of the rules that the legislature has recently enacted. But I understand on an as applied to Mr. Bouza, in terms of a probable cause determination, I understand that there was no issue. In fact, that Mr. Bouza was arrested and there was probable cause prior to the transfer and analysis of his DNA sample, which occurred much later afterward.
That's exactly right, Your Honor, and that's, I suppose, one of the oddities of this case, that my friend points to a lot of differences, for example, between the California and Maryland statutes, but I don't think any of them really apply to Mr. Bouza. He refused to have his buccal swab collected. There were
Argument limited in this fashion? So you're not actually arguing that the state of California has the authority to collect and analyze prior to a probable cause determination, because that's not the facts presented here.
No, Your Honor, that's not our position. We
That
think
fact is actually immaterial to your argument, and that's not really, you're not construing the case in that, with that factual point in mind.
I think it's...
Nor are you urging us to.
Your Honor, we've urged that you apply a general balancing for reasonableness and conclude that this is a lawful search, the search that's required of arrestees at booking.
But to be
That's
clear,
correct.
your argument then extends to every individual who's not in Bouza's situation in the sense that he or she is not convicted in the end. So the 60,000 people, for example, Justice Liu was talking about.
I think that that's right, Your Honor. We think that the statute adopted by the voters, subject to, which should be reviewed under a general balancing analysis, is a constitutional one. This is a reasonable search.
Can we go to the balancing? So King, of course, was a very sharply divided decision, 5-4 at the High Court, and there were very strong arguments on both sides. What is your understanding of the government's interest here? I think in King, there is some wordplay going on as to what the term identification means. There's a narrow meaning of that term, which is to say, is the person who he or she says he or she is? That's, in a sense, somewhat trivial, because that's not really what Justice Kennedy means by identification in King. What he means, instead, is that you're getting some background information, including criminal history and possible crimes committed but not solved, with respect to that person, in order to identify, meaning a better word might be describe, to describe this person. Are we dealing with a very dangerous person? Are we dealing with a person with no criminal history? That kind of thing. And so is it your contention that it's this latter form of identification, not the kind of, are you who you say you are, but rather what is it, who are you in terms of your background, your criminal history, your propensity for violence, these kinds of things that the state is after here?
Your Honor, if I can just preface my response by saying, I think that even if you disagree with the majority in King's somewhat broader understanding of identification, that's not a basis for ruling against us, because the interests described by the majority and in our brief are legitimate whether you understand them as identification or not. And the immediate use of this information is for identification functions. It's for creating a precise identifier that then can be compared with other identifiers to see if they're a match, to see if they came from the same person. And that serves interest.
Flesh that out a little bit. What exactly are you talking about?
So what I'm talking about is, I think, essentially the same as what this court talked about in Loader when it described its words identification function of taking identifiers like fingerprints and photographs and comparing them with other information that's legitimately in government records to see if they match. And it talked about that serving legitimate government interests. And let me explain.
The match is supposed to serve. The match is to say this person is who he says he is?
No, Your Honor. That's one use of identifiers. That's what fingerprints can be used for in the last 2 decades or so. But historically, that wasn't possible even with fingerprints, confirming an individual's arrestee's name quickly upon some future arrest. Historically, and at the time of Loader, the broader identification function of this was essentially exactly what we do with DNA identification profiles right now.
What interest is served by the DNA matching that isn't already served by fingerprinting?
Well, a number of interests, Your Honor, because there are many instances where we have information in government records that is specific to DNA identification profiles, but we don't have fingerprints. And let me give you
unsolved crimes.
Well, let me give you one example. So, for example, in People v. Robinson, this court approved of the practice of having a Doe warrant based on a DNA identification profile. So when we arrest somebody on a felony in this state, the only way that we can check to see if a Doe warrant is outstanding, described by a DNA identification profile, is to have that precise identifier. And Doe warrant or not, information that this individual is connected with other uncharged criminal conduct, previously unknown criminal conduct, is directly relevant to processing him or her for the crime of arrest, for making decisions about bail and OR release and charges and conditions of confinement. And even if we get that information a little bit later after the arrest, it can be a basis for reassessing those decisions.
Doesn't that take us to the heart of the dispute in King, which is that Justice Scalia says on the one side that traditional law enforcement investigation, crime-solving purposes cannot be achieved through these kinds of warrantless searches, and the other side says basically, yes, it can.
Yes, Your Honor, it does take us to that dispute.
So we do have to take a side. I mean, you prefaced your answer to my question by saying you don't need to worry about even if you disagree with King. I'm actually quite worried about that because it seems to me that that very question is at the heart of what other than solving unsolved crimes are you positing as government interests here, based on your matching idea?
Well, Your Honor, if I might, I think there are 2 questions in there. Would it be okay if I respond directly to Justice Scalia's dissent? Sure. Because, if there's anything unsatisfying to me about the majority opinion in King, it's that it doesn't directly respond to the flaws in Justice Scalia's dissent. And it is a vigorous dissent. It's a fun read. But with respect to the late justice, it's just not correct. He makes basically 2 legal moves in that dissent. And the first, as Your Honor mentioned, is that he suggests that a statute like this can only be upheld under the special needs framework. That's just not the approach that courts generally took prior to King, or that the U.S. Supreme Court has taken. I'd point the court to the leading cases before King, the Third Circuit en banc decision regarding the federal arrestee statute. Both the majority and the dissent applied a general balancing for reasonableness, and the majority included all the interests served, including generating leads for unsolved crimes, as weighing in favor of reasonableness. The opinion of Judge Breyer in the Haskell case regarding the California statute, that applied a general balancing analysis, not special needs. Even the state court decision in Maryland versus King, both the majority and the dissent applied a general balancing. And, Your Honor, the second mistake of Justice Scalia in that dissent is that he suggests that none of the interests described by the majority could possibly qualify as special needs apart from ordinary law enforcement if you were to apply that type of special needs framework. And if you look at the other courts that have applied, the minority of courts that have applied a special needs framework to this type of DNA indexing statute, that's not what they've concluded. I'd point the court to Judge Calabresi's opinion for the majority in the Second Circuit in United States against Amerson. He said he had, quote, no trouble concluding that a DNA indexing statute, which he described as having a purpose of helping to solve crimes, serves a special need apart from ordinary law enforcement.
Suppose I accept that. Suppose I accept all that you've said about why Justice Scalia is wrong, why Judge Calabresi is right.